My name is Siobhan Gray and I'm a barrister at Doughty Street Chambers. Today I'm going to be talking to Professor Michael Kopelman, a neuropsychiatrist, about his role as an expert in criminal courts. Professor Kopelman, thank you very much indeed for joining us today. Professor Kopelman will also be talking at the seminar at Doughty Street here on the Thursday the 22nd of June between the hours of 6 p.m. and 8 p.m. when we'll be talking about expert evidence in homicide cases. Professor Kopelman will be talking about amnesia, automatism and criminal behaviour. Professor Kopelman, you've been a leading light in the field of psychiatry now for many years, and you're the Emeritus Professor of Neuropsychiatry at King's College London, and there's a much longer biography at the link below. I just want to ask you some questions about your role as an expert. Ordinarily, certainly from the defence point of view, the first port of call will be a forensic psychiatrist. How does a neuropsychiatrist differ from a forensic psychiatrist, and in what circumstances would you be instructed?
Well, a neuropsychiatrist is interested in the area between neurology and psychiatry. So, for example, I'm interested in automatism, I specialise in memory disorders, other neuropsychiatrists specialise in epilepsy. All of us deal with brain damage and its effects. In particular, for the courts, frontal lobe damage can be relevant because it has important implications for responsibility, and that can result from head injury, from subarachnoid hemorrhage, from drinking too much alcohol, etc. And we're also involved in the assessment of dementia. So it's in those kinds of cases that you would want to call a neuropsychiatrist.
An expert witness is called upon in order to assist the jury with information which is ordinarily outside their knowledge and understanding. In your opinion, what do you think the advocate should do in order to ensure they get the best out of the expert?
Provide good instruction, provide in good time the medical records, ideally in some kind of order with not a lot of duplication, and clearly and concisely say what the instructions are, not ask the same question 5 times over in different language. And then in court, one should obviously hear what other relevant experts say, and again, any advice from the lawyers about how the case is moving, the context in which one will be giving evidence is always very helpful.
And clearly a detailed conference in advance of the hearing itself.
Correct, yes.
Just the other side of that same coin, as an expert, you're often dealing with complex issues and medical terminology. How do you ensure that you deliver your evidence, communicate it to the jury in a way that is easy for them to understand?
Well, I'm a huge fan of Orwell's essay on politics in the English language, which could be called Science in the English Language, and I happen to believe there's very little that cannot be said in simple English. And it's actually a question of habit. If you do that with your patients in the NHS, if you try to speak to them clearly and concisely in a way that they will understand, then it's easy enough to do that in the courts. You have to eliminate what I call psychobabble, you have to eliminate medical nonsense language and just use simple English. But it's doable.
Just turning to another topic, there's been a growing use of MRI scans conducted on defendants, which are then used in the criminal courts. Strictly speaking, it used to be the case where the psychiatrist would go and interview, speak to the defendant and look at the medical records and get an insight into the mental element. How does an MRI brain scan assist in that process?
Well, it assists. It most certainly does not replace. I think we should distinguish between conventional clinical structural MRIs, which are legitimate to be used in court, and research functional MRI, which you see a lot of in television, which in my view doesn't yet have a place in court. But the structural MRIs can tell you if there's a lesion, how extensive it is, where it is, and what the well, it doesn't tell you, but the expert can draw what the implications might be. That has to take place in the context of the clinical history and clinical findings, but it does help say to the court, look, this man is not putting it on, there is a lesion here.
In your view, what do you think are the most challenging areas of psychiatry in the context of homicide cases?
I'm tempted to say legal aid. I'm tempted, the new Coroners Act 2009 does try to make things a bit more objective, but in fact it allows for quite a lot of subjective evaluation in things like whether someone can control their behaviour, form a rational judgment, etc. Also, I'm a little worried in the light of some cases about this notion of recognised medical condition. It sounds very reasonable, but what it amounts to in the courts is whether something is in what I call those bloody books, the ICD and the DSM, which were put together by committees and not necessarily terribly scientific, and allow into the courts as potential grounds for, say, diminished, things like adjustment disorder, personality disorder. The old 57 Act asked for an abnormality of mind sufficient to substantially impair responsibility, and many of us interpreted that as being psychosis, severe mental disorder, fairly severe depression, severe PTSD, not an adjustment disorder.
Professor Kopelman, thank you very much for joining us today. And you'll see from the link below that Professor Kopelman will be joining us again in person on the 22nd of June between the hours of 6 p.m. and 8 p.m. to discuss amnesia, automatism and criminal behaviour. Thank you very much.